Welcome to this presentation on British nationality. My name is Reg Bamford and I'll be introducing Philip Gamble to you, and he'll be covering off on all the ways in which you or your family might qualify for British nationality. Here's what you'll find out, and this effectively represents our guarantee to you. You'll find out whether you have a valid claim to British nationality and to hold a passport, or we'll show you a way in which you can find out the answers. This brings me on to introducing Philip Gamble to you. He is a former Home Office executive. He worked in the Immigration and Nationality Directorate. He's the founder and the managing partner of Philip Gamble and Partners, which was incorporated in 1992. Philip has over 24 years of experience in working in the field of British nationality law, and he is now widely regarded as one of the world's leading experts in that field. Before I hand over to Philip, I just want to introduce you to this slide. We'll use a set of lights akin to a set of traffic lights. Red will indicate a set of circumstances where you or your family have no claim to British nationality. Green will indicate that you have a standard route claim to nationality. But most of you will find yourselves in this amber zone where you're still unsure or unclear as to whether you have a claim or not. We'll have a series of alerts, and this is a set of circumstances which may well apply to you and a good time for you to concentrate. This slide with a green box will show an interesting consequence of a British nationality law. This slide here shows what we call a standard route to British nationality, and there's really no complexity to your particular circumstances here. The first is if you were born in the UK before 1983. The second is if you have a parent, and please note it could be a mother or father, who was born in the UK before 1983. And finally, if you were naturalised or spent a qualifying period of time in the UK in the past. Unfortunately, there might be circumstances where we feel you have no claim at all to British nationality, and I'll quickly cover off on those situations. As a general rule, if you are third generation, that is, you, both your parents and all four grandparents were born in the same country. However, there are three exceptions. The first is if your mother was previously married. Second, if you were adopted. And third, if you or a parent worked in federal Rhodesia in the past. This slide here shows situations where you might have a claim to nationality, and this is where most of our clients fit in. The first criteria is where your country of birth is different to any one of your two parents or your four grandparents. Or you have a UK-born grandparent, or a parent or grandparent was British. Where you were married to a British national, or your parent was married to a British national, or if you or a parent had spent some qualifying period in the UK. So this brings me on to introducing Philip Gamble to you, and he'll talk about the main principles of British nationality and how you or your family could qualify.
My name is Philip Gamble. Over the course of the last 24 years, I've practiced UK immigration and nationality law. The slideshow which follows will give you some practical examples of my work and an understanding of UK nationality law in a little greater depth. It shows you quite clearly that British nationality is not simply a question of being born in the UK, and covers a number of other topics, including birth and descent from former British territories. The slides represent a small snapshot of the things that we've learnt over the last 24 years, and we wouldn't want you to think that if you don't see your particular circumstances coming up on screen, that you don't qualify for British nationality. Before we start, I need to get you used to some terms that we use throughout this slideshow. The first of which is the classification of being British by descent or otherwise than by descent. Now, if we classify you as British by descent, generally speaking, we mean that it's not usually possible to pass citizenship down to a further generation born overseas. And if we classify you as British otherwise than by descent, exactly the opposite applies, and citizenship would normally pass the first generation by descent, at least for those born overseas. The first of our categories is British citizenship through naturalisation. Naturalisation is the term that we use to describe an application for citizenship via residence. And as you can see from the slide here, it comes in two different varieties. For those applying in their own right, 5 years residence is required. For those who are applying and who are also married to British citizens, a residential period of 3 years is required. As you can see, this is generally 90 days in each of the qualifying years, and where one acquires citizenship through naturalisation, it should be noted that this can always be passed to children born outside of the UK in the first generation by descent. So that was the first method in which one can acquire British nationality. The second, and probably the most obvious, is through birth in the UK. Now, the UK has changed the rules on this subject a number of times over the course of the last 50 or so years. If you're born in the UK before the 1st of January 1983, then we can say in 99% of cases you will be British by birth and without question. The rules were changed on the 1st of January 1983 when our British Nationality Act 1981 comes into force. And from that point onwards, it's not sufficient simply to be born in the UK. This will no longer give you citizenship by birth, and in fact citizenship will only be granted if one of the parents has a specific immigration or settlement category at the time. So, children born in the UK after 1983 will acquire British nationality automatically and by operation of law where either of the parents are British citizens at that time. Equally, if either of the parents hold a settled status, generally this would be termed as indefinite leave in the UK, or perhaps permanent residency with other countries, that will also give citizenship by birth. Those who are not fortunate enough to benefit from acquiring British citizenship automatically and by operation of law at their birth can also acquire citizenship later if they were born in the UK. Again, equally, as you'll see from this slide, if a child is born in the UK without any other nationality, i.e. the child is stateless, then a claim for UK citizenship could well exist. And also, after 10 years residence in the UK, if the child is not otherwise qualified for British nationality, a claim by formal application will also exist. Now, one thing we can be certain of is that through any method of acquiring citizenship through birth in the UK, that child will always be able to pass citizenship to the next generation born overseas. The next category that we're going to talk about today is citizenship by descent. Now, as we can see from the slide here, if you have a parent, either parent born in the UK before 1983, then it's likely you're going to have a claim to UK citizenship by descent. For others, the situation is not so clear. Now, I also have to say a few words about legitimacy. In the past, there's been some discrimination in the law about children who are born out of wedlock. And in fact, generally speaking, for those born before the year 2006, it's not possible to claim citizenship by descent through your father if your parents weren't married at the time of your birth. Now, births can be legitimised later by the marriage of their parents after the birth. However, new legislation is coming into force in the near future will actually eliminate any sort of discrimination that we've had in the past on the question of legitimacy. And at some point next year, any person who's been disadvantaged under the old law due to the fact that their parents weren't married at the time of their births will find that they can put forward specific applications to acquire British nationality in the modern day. That should start from around May next year, we feel. Okay, gender discrimination. As we mentioned earlier, the British Nationality Act 1981 came into force on the 1st of January 1983. From this point, the law is gender equal, and one can acquire citizenship by descent from the mother or the father. It may surprise you to learn that those who were born before the 1st of January 1983 can only acquire citizenship by descent through the father by operation of the older law. It may surprise you to learn that it was only in the year 2003 that it became possible for a person born before 1983 to make a claim for citizenship through the female line by formal application. So the laws changed in 1983 when everything becomes gender equal, and then in the period before 1983 it's only been possible in more recent times to make applications for British citizenship if your mother was born in the UK. Now, we say that the mother needs to be born in the UK, but that's not always the case. It may be that you have a mother born in a former British territory, perhaps a British colony, perhaps a British protectorate, and there are differences between the two. As you'll see here, we have a green box that's popped up which represents an anomaly in the law, with the date of the 7th of February 1979 being key. This date represents the date in Parliament when it was announced by the Home Secretary of the time that the law was going to become gender equal. And because the announcement had been made, the Home Office in the UK decided that they would accept applications early and in advance of the law actually being changed on the 1st of January 83. So we have two different classes of application that have been made in the past. Those that applied because their mothers were born in the UK after 1983, and those who applied between the 7th of February 1979 and the 1st of January 83. The latter fall into a very fortunate group. If the application was lodged between 1979 and 1983, although you might think that this would give citizenship by descent because it's coming from a parent, you'll find that those people who registered between those two dates can actually pass the citizenship down to their children as well. So you get a position where you have the grandparent being born in the UK, the mother has to be a female, the next generation being born outside of the UK, but being registered British between 79 and 83 because their mother was born in the UK, and the following generation after that also being able to acquire citizenship. So as you'll see, there are big differences between circumstances of different families. Siblings may very well have different rights to British nationality because they're born either side of a law change, and equally siblings could have different rights to British citizenship simply by their parents taking certain actions at different points in time. So, just to recap on this, if you're born before the 1st of January 1983 and your mother is either born in the UK or has British citizenship otherwise than by descent, you're now able to make an application in the modern day to acquire British citizenship, even though the law at the time wouldn't allow you to have acquired the status automatically. Continuing on the subject of British nationality by descent, we have three distinct groups of people. Those who are not yet born, those that are under the age of 18, and those who are now over the age of 18. This slide represents the position for children not yet born, and the parents hold British citizenship. The law designs citizenship to be passed always in the first generation by descent, and sometimes to the second generation by descent. The slide here shows a number of different positions where it's possible to acquire citizenship in the second generation by descent. The first of which is where the parent has spent a period of approximately 3 years in the UK in the past. So if we have a grandparent born in the UK, the next generation born outside of the UK, but has spent 3 years in the UK in the past, a further generation born overseas, as in outside of the UK, will also be able to acquire citizenship by formal application. Those applications have to be made before the 18th birthday. If you're British by descent, it's of course possible for you to return to the UK and have your children born in the UK. That's always going to give a claim to citizenship automatically. And the third category is where the child is born in a country which doesn't give citizenship automatically at birth. There's international regulations about the desire to prevent statelessness. So if you're British by descent and you can't generally pass that citizenship to a further generation, if it happens, or you indeed engineer the position of your child to be born in a country where the child doesn't acquire the citizenship automatically, again, you'll find that there's a potential application there for UK citizenship for that child in the second generation by descent. This slide represents a practical example of the last point in discussion. So we have two parents living outside of the UK. One parent is British by descent. The parents travel to a country where the child does not acquire citizenship automatically. That child then has a claim to UK citizenship, even where the parent can't otherwise pass citizenship by descent. Better still, usually in such circumstances, the family can then return to their country of origin and then acquire local nationality, again through formal processes, usually birth registration or potentially formal applications for citizenship. Our second category, of course, is for children who are still under the age of 18 as we speak. It's possible for applications to be lodged for citizenship for such children where the parents are British by descent under a number of different circumstances. We've already discussed the fact that where the parent has spent some time in the UK in the past, usually 3 years, but can be slightly less, an application is possible, but applications need to be lodged before the 18th birthday. Those of you who are British by descent, the child is already born, do have the option of coming back and acquiring 3 years residence before the 18th birthday. That will be equally as good, but of course it means you need to settle in the UK before the oldest child is 15 years of age to make sure that you can clock up that 3-year residential period before the 18th birthday occurs. The last category here is where the parent concerned may be British by descent and therefore not qualified to pass citizenship a further generation, but where that parent has worked on a long-term basis for a UK company overseas, and we discuss that in detail next. While the British Nationality Act 1981 was being debated in Parliament, it became apparent that there were concerns for the families of British passport holders living overseas working on long-term assignments for British companies. In other words, what happens to the families of those who are serving the interests of the UK but outside of the UK and multiple generations are born overseas? In view of the debate, it was agreed that routine discretion would be exercised for families in this position. And in the modern day, this means that if your parents and your family maintain strong connections to the UK through perhaps regular visits, ancestors being born here, children going to English-speaking schools, and a number of other factors, and where the parent has worked on a long-term basis for a UK firm in perhaps a Commonwealth country or a foreign country, then it's possible to lodge applications outside of the normal rules, or at discretion, if you like, for those children to become British. The next slide relates to those who are treated as adults now, and for this purpose we mean those who are over the age of 18 years, not over the age of 21. For adults, we have to treat them as individuals in their own rights, and effectively the only way an adult in the modern day can acquire British nationality is either through residential requirements, the naturalisation procedure that we talked about earlier, or if we can prove that a nationality status has been granted by operation of law and by descent from the parents in the past. This can relate, of course, to former British territories overseas, generally Commonwealth countries now, and the decolonisation arrangements associated with those countries. The next slide relates to those who can potentially acquire British nationality or current immigration status through marriage to British citizens. Broadly speaking, we have 3 categories which are created through changes in the law over the passage of time. We have those that are married before the 1st of January 1949. This is when our British Nationality Act 1948 is in force. We also have those who were married before the 1st of January 1983, and those who are married in the modern day. The next alert we have for you represents another set of circumstances where a person can acquire citizenship by having a grandparent born in the UK and using the regulations surrounding marriage. If your paternal grandfather was born in the UK, your father is born in any country whatsoever, and your parents happen to be married before the 1st of January 1949, then you find yourself in a very fortunate position. The basis of this claim shows that in the first generation by descent, the grandfather confers citizenship to the father, and because the regulations before 1949 allowed a woman to acquire citizenship of the husband on the wedding day, you'll find that your mother has also acquired citizenship not through descent, but through marriage. Where a woman has acquired citizenship through marriage, this passes to the next generation down, and when we couple this with our new regulations, which were designed to combat gender discrimination in the older law, i.e. you can now claim citizenship through your mother as well as your father, you'll find that claims for people in this position are eminently possible, and the descendants of women who've acquired citizenship through marriage are now able to make claims for UK nationality through formal applications to the Home Office. The next alert relates to women who were previously married. You would think if your mother was able to claim British nationality through marriage, that if she divorced or if your father passed away, that the citizenship right would be lost. This was not the case. Nothing in the previous law took away status from women who had acquired British nationality through marriage and the marriage had ended. So we have an anomaly which comes in the law where it's possible for claims to be made through mothers having acquired citizenship, not necessarily by marriage to your father, but potentially through marriage to her first husband. So we have a situation here where, again, we have an ancestor born in the UK. The ancestor passes citizenship to a son born overseas in the first generation. That person marries your mother. She divorces him, marries your father, and children from the second marriage can acquire citizenship in the same way as those from the first marriage. In short, this means that you're able to not only claim citizenship through your mother if she's acquired citizenship from marrying your father, but also through citizenship she's acquired through marriage to a former husband, perhaps the first husband. This provision works very much in the same way as the last, in that the woman acquires citizenship by operation of law and on her wedding day. At this stage, however, British nationality isn't granted automatically, and a secondary status called the right of abode was issued instead. The right of abode in the modern day is an excellent status to have. It means that you have the right to come into the UK without restriction, and it's a right that can never be lost. So it's the same, broadly speaking, as what some people would call permanent residency, although it's a status which is with you for life. You can never actually lose that status. So a woman who's married to a British man before the 1st of January 1983 acquires the right of abode. The only other condition we have to apply here is that the woman must be a Commonwealth citizen and must always have been a Commonwealth citizen since the 1st of January 1983. We have obvious problems that come in for countries that have withdrawn from the Commonwealth over the years, the most notable being South Africa. South Africa withdrew from the Commonwealth in 1962 and didn't go back into the Commonwealth until 1994. On the 1st of January 1983, no one who is connected by birth to South Africa can be a Commonwealth citizen on that basis. However, although that seems to be fairly clear cut in that no South African women could possibly benefit from this provision, that's not always the case. It's quite possible for a woman who's acquired South African citizenship by birth to also be a Commonwealth citizen by descent, let's say because her father was born in another Commonwealth country, perhaps Southern Rhodesia at the time, or Australia, or indeed any of the other Commonwealth countries. So although at first sight it looks like no South African women could benefit from this provision, that's not quite the case. Some still will. Now we come to marriage in the modern day. Those that are married to British citizens now are given possibly less rights than one would expect. In fact, if you're married to a British citizen now, you have to come to the UK to establish those rights. A spousal visa is available. It's issued for a total of 5 years, and those that come to the UK and live in the UK for 5 years are able to acquire the permanent resident status at the end of that time. However, it's not an automatic right. These visas have to be applied for and criteria has to be met. In recent times, the criteria has become quite tough to meet, particularly as a financial requirement has been put in place, requiring couples to show that they either have adequate income through employment or through having adequate savings in order to give them a good start in the UK. The requirement goes to such an extent where if you were relying on savings alone, you'd need to show somewhere in the region of £64,000, which is no small amount of money. Where employment's concerned, only the employment from the British spouse will usually count, and we're looking for a figure of £18,600 sterling per year. This can be quite easy to meet for those living in countries such as Australia or America, or indeed those whose British partners are actually already in the UK. But for those coming from countries whose currencies are not so strong, the requirement becomes quite difficult to meet. The other difference we should talk about in terms of marriage in the modern day is that, unlike the provision for the right of abode and British citizenship through marriage, the right only exists while the marriage subsists. In other words, although the right of abode can be claimed by a Commonwealth woman who was at any time married to a British citizen, regardless if that British man is deceased or whether the marriage has been dissolved, in the modern day you can only acquire the right to the marriage visa while the marriage is ongoing. This of course means that if you've been married to a British citizen for 30 years and your British partner has passed away, sadly this means that no right exists to come to the UK on that basis now. Not surprisingly, there are people who can't meet the maintenance requirement, and although being married to British citizens, find that they can't gain entry to the UK. A number of strategies have become apparent which can be taken up by some people, not everyone, to avoid the maintenance requirement, and these are as follows. It's not an exhaustive list, it's a selection. The first of which is where the sponsor to the application has an ability to acquire British nationality. We spoke earlier that there will be people who are Commonwealth citizens now, or indeed foreign citizens, whose mothers were born in the UK, that are eligible to acquire British nationality. Those who are also Commonwealth citizens have a right to a UK ancestry visa. With the UK ancestry visa, one needs a grandparent born in the UK, but no financial requirement exists. There are therefore circumstances where it might be better not to claim citizenship if your mother's born in the UK, but to look to come to the UK with the ancestry visa first, and then perhaps consider converting to citizenship later. So we have those that are eligible for citizenship. If they took it up, their spouses would become subject to the maintenance requirement. If they don't take it up and use a different visa category to enter the UK, the maintenance requirement can be avoided. The second category is very much along the same lines. There are a number of people from Zimbabwe and Kenya who have had to renounce British nationality in the past in order to remain resident in those countries. Those people again have the rights to UK ancestry visas. Those people can use the ancestry visa to come into the UK to sponsor their families and then resume British nationality later, rather than resuming citizenship straight away and making their families subject to these strict financial requirements. In extreme circumstances, there may be people who wish to renounce British nationality and again take an ancestry visa to come into the UK and then reclaim citizenship later. And lastly, we have a provision in the European regulations where if a British citizen decides to exercise European treaty rights outside of the UK in another EU country, perhaps Ireland, that person can rely on European law to sponsor family members into the UK rather than UK domestic law. This again will avoid the maintenance requirement, but will require residence in another EU country first. As you probably realise by now, there's more to claiming British nationality than simply being born in the UK or being descended in the first generation from someone so born. We have a number of exceptions here. We're going to talk about Crown service, former British territories, and the other anomalies that we use on a regular basis to acquire citizenship for those in the second generation by descent. By Crown service, we mean perhaps your parent working for the British military, or perhaps the old colonial service, diplomatic service, or existing overseas service. We have two categories to look at. One for those born after the 1st of January 1983, and another for those born before the 1st of January 83. For those born after 1983, the grandparent must be in Crown service at the time of your parent's birth. This makes your parent British otherwise than by descent and means you can claim citizenship in the modern day. The second category is for those born before the 1st of January 1983. In those cases, we need the parent to be in Crown service at the time of your birth. The next alert we have are for those who have parents born in former British territories, or indeed if you were born in a former British territory. These come in a number of different varieties. As you can see here, there's a number of different types of British territory that we need to look at individually. We have protectorates, protected states, mandated territories, trust territories, and to a certain degree even foreign countries where the UK by treaty or arrangement has the ability to exercise jurisdiction over British subjects in those areas. Where either the first generation or the second generation are born in such territories, we have special effects in UK nationality law, but again they vary through the dates and places of birth concerned. Solution 1 here relates directly to those with connections to former British protectorates, protected states and mandated territories. The applicant needs to be born between 1949 and 1983. The parent needs to be born in the former British protectorate, for example, and the grandparent needs to be born in the UK. So, for example, we could be looking at a situation where the grandparent's born in the UK, the parent's born in northern Rhodesia, now Zambia, perhaps in 1958, and the applicant's born in South Africa, perhaps in 1976. Such a person now has a very good chance of claiming citizenship through the grandparents' connection with the UK and the middle generation being born in the British protectorate itself. Solution 2 is the same as the first, but it involves you as the applicant being born in the British protectorate rather than the parent being born in the protectorate. Solution 3, very much along the same lines as the first two, but this time the parent is born in a British colony rather than a British protectorate. This would include places like Kenya, Seychelles, Hong Kong, and many others. The first three solutions related to persons born before the 1st of January 1983. The second set of solutions we have here are for those born after the 1st of January 1983. These are not so numerous. Where the grandparents born in the UK and the parents born in a former British colony, perhaps the Kenya colony again, children born after 1983 can still have a claim in the modern day. Equally, as in solution 2 here, where the parent is born in a protectorate before the 1st of January 1949, and the applicant, yourself if you like, is born after the 1st of January 83, coupled with the UK-born grandparent, again, a claim is eminently possible in the modern time. Again, where we have grandparents born in the UK and connections with Southern Rhodesia or Zimbabwe, with you as the applicant being born between March 70 and April 1980, we believe that there's potential for claims for UK citizenship. The 1970 to 1980 period relates specifically to a period within the UDI period of Zimbabwe, where the government of the day was attempting to have Rhodesia, as opposed to Southern Rhodesia, recognised internationally as a republic. The next alert relates to people born in South Africa, specifically between the 31st of May 1962 and the 1st of January 1983. This period is the period in law, for the purposes, I should say, of UK law, which South Africa is outside of the Commonwealth and before our British Nationality Act 1981 comes into force. Again, a grandparent has to be born in the UK, and you as the applicant have to be born in this date range. We'd mentioned earlier that there were effects for birth in foreign countries where the UK was seen to exercise jurisdiction over British subjects in that area at the time. There are various parts of the UK law relating to South Africa's exit from the Commonwealth, which lead us to believe this was the case in South Africa between those dates. This slide relates specifically to those connected to Rhodesia again. It's a tried and tested method, doesn't represent any element of research, and persons who fall into this category can make applications straight away. In the early 1950s, the territories of Nyasaland, now Malawi, Northern Rhodesia, now Zambia, and Southern Rhodesia, now Zimbabwe, formed a federation. The federation was recognised by the UK as an independent, self-governing Commonwealth country. This state of affairs existed until the 31st of December 1963. Many South African citizens went to the Federation to work in this period, and they'll find, or they will have found at the time, that it was expedient to acquire federal citizenship rather than relying on work permits to take employment in the area. Those South Africans who registered as federal citizens in this period and then left the Federation after 1963 will find that they have claims to UK citizenship if they didn't then become citizens of Southern Rhodesia. So this, if you like, is another category or provision where one can acquire UK citizenship, potentially without any connection to the UK at all. This is simply by connection to Federal Rhodesia, having become a federal citizen at certain points in time. This slide represents those who have ancestors born in Ireland. Any person who has a parent or a grandparent born in Ireland itself will have a claim to Irish nationality now. It may seem strange that this includes Northern Ireland as well as the Republic of Ireland, because Northern Ireland is part of the UK and not part of the Republic now. This is not a mistake, and it comes down to the fact that when the Constitution of Ireland was written, it was envisaged that Northern Ireland would become part of the Republic at some stage. Over the passage of time, Northern Ireland has stayed part of the UK. Nevertheless, claims to Irish citizenship can still stem from a grandparent born in Northern Ireland now. I should say a few words about adoption. Most people believe that if they're adopted by a British citizen, that they will acquire British citizenship automatically. Sadly, this isn't the case. Adoption in the UK always leads to the grant of British citizenship. Adoption overseas does not have quite the same beneficial quality. Adoption is a complicated area, and adoptions which take place in some countries are recognised in the UK, others are not. In the past, if you were adopted in a Commonwealth country, you could have a claim to the right of abode, a status which we've already mentioned. But generally speaking, only adoption in the UK will allow a grant of British nationality. There are some other exceptions and anomalies which we want you to take account of too. All of these will give you a steer in terms of whether it's likely you'll have a claim to UK citizenship or not. For example, your birth may have been registered at a British consulate overseas, or your name may have been included in a parent's British passport. These again can be good indicators that you could potentially have a claim to UK citizenship. Equally, you may find that your parent had a British passport at some stage in the past, potentially because they were connected to a former British territory. I should also mention that those of you who've applied for citizenship in the past and where the application has either been rejected or potentially abandoned, it's quite possible to have those applications reopened in the modern day. For example, a woman who was entitled to acquire citizenship through marriage applied for the status in 1979 and the application was simply abandoned. It was never determined. Such an application can now be reopened in the modern day and the application finished and granted now. This is an anomaly for UK nationality law because, of course, if you were refused a visa or an immigration status 10 years ago, there would be no recourse to having this reopened and granted in the modern day. This slide shows that we have a number of different forms of UK citizenship in use at the present time. These are as follows: British citizenship, British national overseas, British overseas territories citizen, British protected person, British overseas citizen, and British subject. All of these statuses allow the holders to acquire British passports in the modern day. British nationals overseas are specific to Hong Kong, those people who were connected to the former colony of Hong Kong before 1997. British overseas territories are, if you like, existing UK colonies overseas and include such places as the Falkland Islands. British subject status was the form of UK nationality in force before the 1st of January 1949, and some persons connected to Ireland and former British India still hold this status in the modern day. A British protected person, as the name suggests, is a person connected to a former British protectorate. Again, such persons are entitled to British passports and on certain occasions have the ability to upgrade those to full UK nationality now. A British overseas citizen is a person who's connected to a former British colony which remained as a colony in the period after the 1st of January 49. This includes places like the Seychelles and Kenya, but of course doesn't include India. With UK immigration, over the course of the last few years, things have become a little tougher. Many visa statuses have actually been scrapped. We've lost the 2-year working holiday visa for a number of countries worldwide. We've lost our skilled migration in terms of the points system. We've lost our post-study work visa, and the sponsorship of elderly parents has become so difficult to meet criteria on that we see very few applications now. We still have the UK ancestry visa, marriage visas, work permits, study permits, and a number of other categories. With the UK ancestry visa, this is the last visa which benefits Commonwealth citizens only. Any Commonwealth citizen over the age of 17 with a UK-born grandparent, I should say any one of the 4 grandparents, can qualify for this visa. Those taking the visa are expected to come to the UK to take employment, and those that stay for the 5-year duration can apply for permanent residency at the end, and in the following year can apply for naturalisation as a British citizen. Although one would think that perhaps those who are past retirement age couldn't apply for the visa because it requires an intention to work, this is not the case. The UK cannot discriminate against you on the basis of age, and as long as you're fit and able to work, the visa can still be granted. Whether the visa continues to be granted for the future, we can't say. It's the last visa, as we said, that benefits Commonwealth citizens, and it hasn't been updated in the same way as the spousal visas in terms of maintenance requirements. One thing we can say though is that if you've acquired the visa, if the law changes, the status won't be taken away from you. You'll be able to still use that and come to the UK for settlement. The UK still has two visa classes for those wanting to come for business and for investment purposes. For business visas, as you can see, an investment of £200,000 is required. The visa status lasts for 5 years, and again, applications for permanent residency are possible at the end of the 5-year period. In recent times, this visa has been modified to allow two persons, or two families if you like, to put up the £200,000, perhaps £100,000 each. So, as we can see here, the category has been made slightly easier to qualify for. With investment visas, £1 million is required, 750,000 of which has to go into active UK trading stock or perhaps government bonds, and the other 250,000 must be invested into UK property. Again, the visa lasts for 5 years, and it's possible to acquire permanent residency at the end of that status. For those of you who are lucky enough to be able to invest more, the residential period is cut down to 3 and 2 years respectively for £5 million investments and £10 million investments. All applications for British nationality have to maintain a number of different features. For example, they have to be lodged with the right authority. The right authority at the time of speaking is the Home Office in the UK, not British High Commissions or consulates overseas. Proving your nationality claim. This is not always an easy task because, as you've seen, many documents can be required from the past which may or may not be available. The standard of evidence required for proving a claim is called the balance of probabilities. Not perhaps beyond reasonable doubt, as would be required for a criminal trial and to prove a criminal case in the UK. The balance of probabilities in this context means that if there are missing documents, alternatives could be used to substantiate the claim. For example, if a birth certificate's missing, a baptism certificate may suffice. Otherwise, perhaps the last will and testament of an ancestor may list the next generation as the beneficiaries to prove the claim from a parent to a child. Wherever, however, you go outside of the usual parameters for evidence and documents are missing, Home Office approval is usually required before a passport can be acquired. In the event that there are lost documents, we may be able to assist with finding replacements. There are various archive offices around the UK and in other countries who can provide duplicates where the records still exist now. Submitting an application. This may not be always as straightforward as it seems. The application has to go to the correct authority. It has to have a fee, has to have the right evidence, and certainly in the more complex claims, it's beneficial to add the legislation and an explanation of how you actually qualify. These may seem like obvious things to say, but if you've got a child who is 17 years and 11 months, if you send papers to the wrong government office, you may find the application rejected and the child's rights lost forever on a very simple error. With application forms, you'll find some available on the UK government websites for the more straightforward applications. However, it's more difficult to prove a claim if you're relying on descent from former colonies or protectorates, and ideally, detailed descriptions of how one qualifies should accompany such applications.
Thanks, Philip. Well, there you have it. You should now know whether you have a claim to British nationality or you don't. So if you find yourself in that amber zone and you're still unsure of your claim to British nationality, well, we think you have 3 options. 1, you can go and do your own research. 2, you could contact your local embassy, or you can ask an expert, someone like Philip or his team of nationality experts, for a final definitive answer. So if you were to contact us, we've designed a very straightforward 4-step process in order to find that answer. We've designed this so that you can avoid any unnecessary time or application fees that go to the Home Office. So the first step is a very simple one. It's to simply determine what type of application you might have. Do you have a standard claim? Do you have no claim? Or do you have a non-standard claim, i.e. you think you have a claim, but you're not sure how? So if you think you have a claim, we ask you to move on to step 2. And this is where you complete a free British nationality assessment on the website called whatpassport.com. It's a site that Philip has built, and it contains all the potential British nationality solutions for you and your family. There are 2 potential outcomes. First, it could indicate that you have no claim. Or second of all, it will list all the other ways in which you and your family could qualify. Moving on to step 3, we call this the British Passport Review. This is where you can ask Philip to have a look at your online family tree that you created in step 2. Philip asks about 20 relatively simple questions about you and your parents and your grandparents. And these are filtered against all the solutions that we have on that website. There are 5 potential outcomes to this British Passport Review. The first is none, where Philip believes that you do not have a claim. The second is unlikely. The third, possible. The fourth, it's likely, and you have a strong claim. And finally, you have a definite claim, what we call a standard route to British nationality. Based on the answer that you get to that British Passport Review, you can move on to our 4th step. So you move through to the 4th step if you feel that you have a reasonable chance of having a valid claim, but we now have to validate that for you, and that involves some research. We call this a status trace, and you instruct Philip Gamble and Partners to research your claim. They will write a multi-page report on their findings and why and how you might have that valid claim. This status trace report covers your entire family unit, yourself, your spouse, your children, even your parents and grandparents. Thank you very much for listening to this presentation on British nationality. We hope that you enjoyed it, and good luck with all your future inquiries.